Is it actually legal?
So there are still possession, if you read the statute, there were possession limits put in the statute.
The program also includes regulation on possession limits.
So people can still be arrested for a possession if they, go beyond the legal amount. So things are legalized, but it's not legalized completely. I don't know that we need to continue to put limitations on possession as we move forward. But as of now, and based on statute, that would be illegal to have a certain level or possession amount.
It's important to understand that small amounts of cannabis had been decriminalized by then Governor Bruce Rauner in 2016, almost 4 years prior to the new law taking effect. Under that system, possession of 10 grams or less of cannabis was punishable by a small civil fine between $100 and $200. According to legal professionals, under this old system, possession of a few grams more than the legal limit of 0 grams incurred a small civil fine. Under the new law, however, possession of a few grams over the legal limit, say 32 grams, is not punishable by a small civil fine, but by a Class A misdemeanor and up to a year in jail.
There's something wrong. Make it a fine-only offense, I guess. I mean, if you want to make it I don't think you should make it an offense at all.
Sure.
But if you do want to make it an offense, like, do we really have no tools other than criminal law?
Right.
Give them a ticket. All of these criminal laws still exist. They're all still enforced. They all still are. If you fall off that tightrope, if you're from Indiana and you've got your 16 grams, which you're not allowed to have because you're not a resident, to fall back into the criminal law, the pre-existing criminal law that uses jail time and probation and fines, high fines as a mechanism of enforcement, we're not being progressive.
Yeah.
Like, we're saying we're progressive as a state on cannabis, but we're obviously not living up to that if our only tool for enforcement is criminal law.
This law will not legalize drugs for our communities. This legislation will still see devastation on the behalf of those who are stopped by the police as a result.
That was a peek at my upcoming mini documentary. If you'd like to be notified when I release it, you can go to thecolememo.com/subscribe, or you can go to thecolememo.com/Patreon, as it will release on Patreon first. Thank you. Enjoy the episode. In so many different ways, the legalization of cannabis in Illinois seems to have fell short of its original promises. And that's, something that we can continue to work to perfect. If you're not sure what exactly I'm referring to, there are, like I say, several shortcomings to legalization in Illinois. In fact, I don't think it's fair to say that we have legalized cannabis in Illinois. I think it's more fair to say that we've created a system for the regulation and taxation of cannabis, which allows adults to purchase tiny quantities of cannabis from a small amount of state-ordained operators. For so many ways, I think this falls short of what we originally had in mind because, for example, if you exceed the tiny quantity that you are allowed to have under this new framework, you are still subject to the old penalties as they were originally prescribed. And you don't have to take my word for it. We've talked to several defense attorneys about this exact subject. In fact, the Cannabis Control Act of 1978, which originally established the criminal penalties, is still the primary enforcement mechanism for all cannabis-related infractions in the state of Illinois. That's right. Every penalty related to cannabis is still on the books. Most of the penalties, the only penalties that were really changed were the possession of tiny quantities of cannabis. If you'd like to learn about how these shortcomings affect real people, you can go to thecolememo.com/isitlegal, because I'm always asking, is it legal if you can go to jail for simply having, quote, too much cannabis? I don't even know what that means. I'm always wondering, is it legal if you can get arrested for simply possessing cannabis in your vehicle in an unopened container? That's an actual story that you can listen to at thecolememo.com/is it legal. Today's episode is just another example of a shortcoming related to the legalization of cannabis. This one actually started before cannabis was quote unquote legalized. This actually began when cannabis was decriminalized in the state of Illinois in 2016. Thecolememo.com/is it legal? Is it legal? Enjoy the episode. This is the Cole Memo. I'm your host, Cole Preston. Every episode is released in audio, video, and transcript format. To find the transcript, audio, or video version of any episode, please refer to the description of the episode that you're listening to now. Within that description, you can find a link that will take you to our website, which will display the transcript for this episode and the platforms where you can find this episode in audio or video formats. If you're unable to locate the episode description on whichever platform you're listening from, simply note the episode number and visit thecolememo.com. From there, you can find the corresponding episode using our search functionality, and then you'll be able to access the audio, video, and transcript version of that episode. You might also find any links that we reference during the episode so that you might be able to do your own research. If you're not listening to this episode of the Cole Memo on Patreon, then you're listening to this episode later than our patrons. In fact, I released this presentation, I think 3 weeks ago. To become a patron, go to thecolememo.com/Patreon. It only costs $3 a month, and you get exclusive access to our episodes as they release. It's a great way to support our show. Another way to support our show is at thecolememo.com/support. One of the best ways to support our show is free. Subscribe to or follow our show. If you're watching right now, please give us a thumbs up. Leave us a positive review from wherever you're listening to us or watching us from. Favorite this episode, give it a thumbs up, leave a comment, or share it with your best friend, retweet it, whatever you're watching this on. The video version of this episode is also released on Twitter or X nowadays, in addition to YouTube, Patreon, and any other video platform Spotify, for example. I just want to say before I send you into this presentation, your engagement and support is appreciated. Today is May 22nd, 2024. But again, this presentation was released first for our patrons. Enjoy this episode of the Cole Memo. Hello and welcome. Have you consumed cannabis in the past month? If the answer is yes, it's crucial to understand that operating a motor vehicle within the state of Illinois could result in legal implications for you, even if you're not currently intoxicated or haven't been for several days, weeks, or even months. So bear with me here, folks. I'm going to jump in from time to time here with a little bit of a fact check on myself. I ran this episode by a subject matter expert, and they offered what you might call some fact checks. So the first one on what I just said. They say a few times in the presentation, you say that you can be over the limit of THC in urine based on this procedure for months. We're going to get into what I'll break down what exactly I'm about to say, but just to be clear, THC glucuronide, which is what we talk about in this episode, is present in the urine of chronic cannabis users for up to 24 days, not months. What I was referring to was carboxy THC, which is a different metabolite of THC, and it can be found in the urine of chronic cannabis users for months, but at least right now, no one is asserting that carboxy THC can be the basis for a DUI cannabis charge. In this episode, I'll be explaining why the per se limit for cannabis in Illinois is impossible to comply with. Another fact check here. my subject matter expert says in the opener, I say that the DUI statute, the current DUI statute, is impossible to comply with if you are a chronic pot smoker. They say, I think that is true when you're talking about the distorted UIC interpretation of the DUI statute. We'll get into what they mean by that in this episode. But the normal common sense interpretation of the DUI statute is that delta-9 THC means delta-9 THC and does not include non-psychoactive metabolites of delta-9 THC. Once again, we'll get into that in this episode and what that means. Under the normal interpretation of the DUI statute, my subject matter expert says you will not drive over the limit of delta-9 THC, which is 5 nanograms for blood, unless you drive within hours of consuming cannabis. The key here is blood, I would say. More on that later. That was my last fact check. Enjoy the rest of the episode. And I thought that the best way to maybe do this is to share the presentation that was shared with me. But before I do that, a little bit of background. In case you're wondering what a per se limit even is, let's talk about how it became a part of Illinois law. So in 2016, Illinois decriminalized small amounts of cannabis. Under the 2016 law, those caught up with up to 10 grams of marijuana faced fines of $100 to $200. Individual municipalities could add to the fines or implement other penalties, such as requiring offenders to attend drug treatment. I think some of those provisions still exist today. Citations were reportedly set to be automatically expunged twice a year on January 1st and July 1st. Individual municipalities could add to the fines or implement other penalties, such as requiring offenders to attend drug treatment. Once again, I believe we've seen that continue. I didn't mean to mention that twice, but it is important to mention that I believe the requirement to attend drug treatment is still required. If you would like to see at least one story I'm aware of where something like that was required, you can go to thecolememo.com/isitlegal. David's story, he got in trouble and was required to go to a sort of drug treatment. I can't remember exactly what it was, but it sounded like this. The law, also the 2016 law that we were just talking about, also changed the state's zero tolerance policy for driving under the influence. In doing so, Illinois created a per se limit. A per se limit is the concept that allows the state to assume you're guilty of driving under the influence, even if the state is unable to prove impairment. In the past, Illinois Representative Bob Morgan has indicated that the Illinois threshold is arbitrary, saying, quote, "We literally made it up." Let's watch that clip before we go any further. I am about to share my screen for folks that are watching this version of the podcast, this episode of the podcast, rather.
There's still an element, and it continues to be a major problem of intoxication, driving while intoxicated with cannabis, because we don't have a .08, nor do we have technology to even enforce that if we did have any kind of standardization. So there's no per se limit. Illinois actually has a per se limit, but we literally made it up. We made up the per se limit. It's not based on 50, 60 years of driving while intoxicated with alcohol that we know. .08 is the average. And yet we all know somebody who's 90 or 100 pounds who drinks one beer and can't drive. And we also know people who drink 12 packs and are just fine, because the body absorbs alcohol differently. Same with cannabis. Some people that are regular users are not necessarily impaired, even if they're using quite a bit.
So, I mean, Illinois Representative Morgan said it himself. Some people could be, thought to be impaired, even though they're not. I've come under the understanding that these arbitrary thresholds have created complications for cannabis users in Illinois. That's why I started off the show saying if you use cannabis at all, you should be mindful of this. Particularly during traffic stops is when you need to be mindful of this. When you are operating the motor vehicle, many individuals find themselves being charged with intoxication despite not being impaired. From what I've been able to gather, beyond the low threshold levels, the real concern is the methodology that's practiced by one of the only labs in the state of Illinois that I've come to understand is certified to perform this type of testing. in response to the change in the DUI statute in 2016. So let's pull up the presentation that I saw. Now, I'd like to reiterate, I saw this presentation. I didn't make this presentation. And so as a result, I'm going to be going through my notes and doing my best to share this presentation as it was taught to me, or as it was presented to me, because I think there's a really interesting case in here. I just wanted to say that because you'll notice, I think on slide number 2, there's a direct, an endorsement of, I think, 1 or 2 laws or both. And I guess I just wanted to be clear that it's not me necessarily that's endorsing either law, but I think it is interesting to see what the laws, or either I said either law, I meant to say bill, either bill. It is interesting, though, to see what these bills do. But before we talk about that, let's lay out why the Illinois DUI cannabis law is basically, well, it is impossible to comply with. So first of all, driving under the influence, here are the relevant statutes. I'm displaying them right now. It looks like driving under the influence of drugs is 625 ILCS 5/11-501A7. And the other relevant statute is chemical and other tests 625 ILCS 5/11-501.2A6. And these bills they're treated as one, but they really reference each other from what I understand. So again, these are the current per se DUI cannabis statutes. And here are some bills that you can research yourselves, 3409 and 4890, which seek to change how this works. So just to put it down in a bottle, since 2016, a person is automatically guilty of DUI cannabis if they have more than 5 or 10 nanograms per milliliter of blood or other bodily fluid of Delta 9 THC within 2 hours of driving. So this is really important to fixate on the fact that Delta 9 THC is listed in this statute as it currently stands. The state does not have to prove impairment to find somebody guilty of driving under the influence as long as you exceed either one of these thresholds. So once again, I said Delta 9 THC is a really important part of this conversation. And, you know, if you've been watching this show over the past, I don't know, a couple of years or so, we've really been diving deep into the difference between Delta 9 THC and other cannabinoids. So if you don't know, let's do a little bit of a breakdown on the background behind the science. If you've not been watching over the years, this is a little bit of more of a formal education that I'd be happy to share. So Delta 9 THC is the main psychoactive constituent in the cannabis plant. Toxicologists in particular refer to this as free THC or parent THC. And again, I want to say that this is primarily by toxicologists. Laymen and scientists outside of toxicology do not use these terms. Remember these terms, free THC and parent THC. As the presentation says, these are not used in common parlance, but by toxicologists. Delta 9, this is what we've talked about a lot on the show, is not naturally occurring within the plant. Instead, the plant produces THCA. When heated, THCA converts to Delta 9 THC, and Delta 9 THC is what is typically associated with getting people high. The important fact to know about Delta 9 THC is that it's found in your blood and saliva, but as you can see due to this last point that I'm displaying here, it's not found in your urine. I have been told that if you have certain types of organ failure, like kidney issues perhaps, you might end up with it in your urine, but typically there are only metabolites for Delta 9 THC that end up in your urine. So, Delta 9 THC is not water soluble. And this is important to understand. It's not water soluble. So your body turns THC into other molecules called metabolites that are water soluble, ultimately so that you can excrete them, which I think is a disgusting word. But in other words, so that you can pass them. In other words, urinate, ultimately, whatever is created cannot be destroyed, right? So you've ingested these things, they've turned into they've turned into metabolites so that you can metabolize them. And ultimately, one of the main metabolites that's found within cannabis users is called conjugated THC, otherwise known as THC glucuronide. I'm probably saying that wrong. Glucuronide. It's formed in the liver by chemically bonding THC to glucuronic acid, which is, from what I'm told, basically just a sugar molecule. And conjugated THC, or THC glucuronide, can be found in cannabis users, in some studies, up to 24 days after they've used cannabis. It's not known to have any psychoactive effects or to correspond with any level of impairment. As I mentioned earlier, it's formed in the liver by chemically bonding THC to glucuronic acid, which is basically just a sugar molecule. And this is important to understand. It can be turned back into THC within the lab. So at this point, you might be wondering, what do you mean, right? So you've got delta 9 THC, and it converts to 11-hydroxy delta 9 tetrahydrocannabinol, oftentimes. And that will convert into 11-nor-9-carboxy delta 9 THC. I'm speaking a little bit out of term here, so I am going to play a video in a moment just to back up what I'm showing. But ultimately, as I said, this all ends up being conjugated THC, which is present in the urine, but not the blood. So here's a comparison between conjugated THC and THC, delta 9 THC. And here's what I really want you to notice. If you look at THC on the left here, this is the chemical structure of THC. I used to have a shirt like this. I even had like jars that would have this. I used to think the chemical structure of THC was really cool. I don't know why. But over here, you can actually still see the chemical structure of THC. I'm circling it here. Now, this part is the glucuronic acid that is binded to the delta 9 THC, thus creating an entirely new molecule called conjugated THC, or THC glucuronide. So you might be wondering what's happening, right? What's the issue? People are being charged and found guilty under the 501A7 statute with being over the legal limit of delta 9 THC in their urine, even though none of them have that much delta 9 THC in their urine, right? They didn't have that much delta 9 THC in their urine because, once again, delta 9 THC is not found in your urine. So how, right? How is the question? We're going to get to that. As I promised, I wanted to play a video that kind of backs up the science that I just laid out. Let's watch this video. Just a reminder, I'll have this video linked in the podcast description if you'd like to watch it at your own pace. It's a very short video. Let's take a look.
The pathway of marijuana in our body can be split into 3 phases: consumption, metabolism, excretion. Tetrahydrocannabinolic acid, or THCA, is a cannabinoid found in raw cannabis. It's not psychoactive and doesn't cause a high effect. THCA becomes THC when we smoke. Then THC goes into the lungs, and next to the blood. About 70% of the THC is taken up by tissues, primarily by body fat, and 30% is metabolized. From the body fat, THC is slowly released back into the blood. So THC is continuously moving from fat into the blood and back again. With the blood, it gets into the liver, where it is metabolized in 2 phases. In the first phase, enzymes convert THC to 11-hydroxy-THC. Then enzymes convert 11-hydroxy-THC to 11-nor-9-carboxy-THC. During the second phase, THC metabolites are prepared for excretion. UGT enzymes add a glucuronide molecule to metabolites. These metabolites are soluble in water. They dissolve in the bile and water and are excreted into the urine and the intestines.
Glucuronide. I guess that's how you pronounce it. Before we move on and get back to what the issue is, I just wanted to insert a little bit of comedy. If you recognize the reference to another cannabinoid, I'm just going to play a short clip. All right. Once again, this is a short clip that I'm going to play. I've played it on the show in the past, but it's just a little bit of comedy that adds to this conversation in case, once again, you recognized one of the cannabinoids we were just talking about. Let's play the clip.
See, the thing about edibles, one of the problems with it being illegal is that a lot of us don't have a lot of information that we could use. Like, there's a difference between smoking it and eating it. When you smoke it, you get THC, but when you eat it, it's processed by your liver, and it produces something called 11-hydroxymetabolite. That's 5 times more psychoactive than THC, and it lets you talk to dolphins.
All right, just a little bit of comedy before we get into the issue. Let's talk about the issue, shall we? So, once again, from what I've been able to gather, beyond the low threshold levels that are seemingly arbitrary, according to Illinois Representative Bob Morgan, the real concern is the methodology that's practiced by, from what I've been led to believe, one of the only labs in the state of Illinois that's certified to perform this type of testing in response to the change in the DUI statute in 2016. I thought I was done with fact checks. I think this is my last one. I want to be clear. From what I understand, UIC is not the only lab certified in the state to do this testing. They're just the only lab that's certified in the state that chooses to do the testing in this way. Let's return to our PowerPoint presentation that I was sharing. So it's this concept of hydrolysis. The University of Illinois at Chicago, the Analytic Forensic Testing Laboratory, has adopted a 3-step process of testing urine samples in DUI cannabis cases who, at least according to the testimony of an expert that I will share later, who is actually against cannabis. This is an anti-cannabis subject matter expert. They seem to indicate that the University of Illinois is one of the only labs that they are aware of in the world that employ this methodology in their testing. Unless I'm misunderstanding them, that's what they seem to imply. Again, I'll share that testimony in a moment. Let's talk about the 3-step process of testing urine samples in DUI cannabis cases, as I was told it goes. First, apparently, they test the sample for delta-9 THC, which always comes back either completely negative or well below the 10 nanogram per milliliter threshold, because once again, delta-9 THC is not water soluble. You're never really going to find delta-9 THC in your urine unless, I've been told, you're having some issues with your organs. 2, the samples are then hydrolyzed, which is a chemical reaction breaking the bond between the glucuronic acid and THC, thus turning conjugated THC back into delta-9 THC, otherwise known as, remember, free THC. That's what we all want. No, I'm joking. That's what toxicologists refer to as delta-9 THC. They also call it parent THC, as a reminder. Finally, after hydrolysis, the lab then retests the sample, which often shows a delta-9 THC concentration that is, quote, over the limit of THC. Now, this is problematic from what I've been told, and from what I've read. You know, it's causing people to be arrested, frankly, because when they aren't provably intoxicated, which is really one of the number one issues with cannabis use in and of itself. There's no real way to prove current levels of intoxication. I have been told that if you take a blood sample, you can at least see, because delta 9 THC can be found in your blood. You can at least see within the last, I would say, I think I was told 4 or 5 hours, if somebody has consumed cannabis. You still can't gauge a level of impairment, but you can at least see, well, they have delta 9 THC in their blood, which I've been told strongly indicates that they have consumed cannabis within the last few hours. So, this is a problem, right? So here's the process as it occurs. So you've got your delta 9 THC, your free THC, your parent THC, which is consumed by the pot smoker but is not present while urine is in the bladder. It gets metabolized in your body, turns into conjugated THC. It's present in your urine when the pot smoker pees into a cup. It goes to the lab, they conduct hydrolysis, and all of a sudden, after it's retested, after the hydrolysis, the conversion method they employ, your total delta 9 THC is now over the legal limit. So it seems like the big argument comes down to whether or not this is a new molecule. I will just say that, and that's what we'll get into in some of the testimony. It seems like the main scientific debate is whether or not you're creating a new molecule. From a layman perspective, it seems like you are, because you're literally performing a conversion on it. Just like your body converted it from delta 9 to conjugated THC, you are then converting it back and you are affecting that molecule. That's just from a layman's perspective. But how do those results get reported to law enforcement? So UIC then apparently reports post-hydrolysis results to prosecutors as an amount of total delta 9 THC, including both free and conjugated cannabinoids, which is a problem because if the number is reported higher than 10 nanograms, most prosecutors and defense lawyers interpret that to mean the defendant was driving over the limit of delta 9 THC, even though, once again, at the time the urine arrived at the lab, there was 0 delta 9 THC in it. So how are people found guilty of this? I'm told that reason number 1 is confused attorneys. Most attorneys, of course, do not have a scientific background. Combined with the way that it's reported and represented, it leads lawyers to believe that their clients are driving over the limit. They're being presented with this data from the state. It seems clear. They don't have a scientific background to understand that that's not how it arrived at the lab. And so, the majority of defendants who are charged with DUI under the A7 statute, based on the results of the urine tests, plead guilty because their lawyers tell them they should. I'm told that reason number 2 is fear, the fear of taking a case like this to trial with the risks. They feel they're too high. And even if they understand the issue, if you get an offer that looks favorable and you don't have a subject matter expert waiting in the wings, you might just plea out because you're afraid of being found guilty and getting a worse sentence. This is the thing, from what I understand, at this point, you have to get a subject matter expert to try to argue this. I'm not one. I've just learned it, I guess. I've gotten the secondhand smoke of this understanding, for lack of better words. I am definitely not one, but if you want to beat this in trial, you need to get one, somebody that actually knows their science. Because I'm told reason number 3 is that people have given false assertions in the past. I spoke to one person that described a case where an individual named Dwan Thompson was found guilty at trial under the A7 statute, even though they had no delta 9 THC in their urine when they drove, because they weren't experiencing an organ failure of any sort. So it's just impossible for it to be found. Apparently, the laboratory technician claimed at Mr. Thompson's trial that conjugated THC is not a different molecule than delta 9 THC because no carbon bond was added or taken away. The appellate court held, based largely on this false assertion, that a rational finder of fact could find Mr. Thompson guilty. You can actually see Mr. Thompson's case here. They've got it cited. And I was told that not only did the appellate court uphold this ruling, they also didn't make a clear ruling about what the word means, the word Delta 9. They refused to rule as a matter of law what the word Delta 9 THC means, which means they left it up to each individual trial court to decide the meaning of that word. My legal subject matter expert on this tells me, quote, "That's bizarre to me. When you go through law school, one of the things you learn is that one of the rules of the appellate court is to clarify the meaning of the statutes. If a statute can be read multiple ways, it is the job of the appellate court to clarify the actual meaning of that, and they refused to do that. As a result of this, you're guaranteed to get different results for the exact same conduct," end quote. In other words, two people who have the exact same number of THC glucuronide in their urine are going to have radically different outcomes based on several factors. Who has the better lawyer? A lawyer that actually understands this issue. If you can afford to, like I say, hire a expert witness, and you're going to need it, like I said, given testimony that has recently been given. Are you in front of a judge that views the statute more narrowly or more broadly? And what assertions are made by UIC analysts at trial? I've been told that another UIC analyst has given testimony that's different than the one that's being cited here, where they admitted THC glucuronide is different from Delta 9 THC and the legal so there seems to be, even within UIUC, or I keep saying UIUC, that is a different college. What I mean to say, within UIC, the University of Illinois in Chicago, there seems to be differing opinions, but it seems like there is one lead expert, but it all depends on which analyst you get. So I've been told that the whole field of forensic toxicology is trying to move law enforcement and legislators away from using urine, because no urine test can be correlated to impairment in any context, and that's for any drugs. Unfortunately, cannabis is different in that people can legally consume cannabis and, without exaggeration, days or months later, be pulled over, and you will be, quote, over the limit based on a distorted interpretation of the law. So as I was just mentioning, forensic toxicologists are really trying to make the point that urine testing is not correlated to impairment. You cannot determine if anyone is under the influence of any drug or mind-altering substance by testing somebody's urine. So, as a result of all this, innocent people are being found guilty by both legalizing cannabis and allowing this issue to persist. The Illinois General Assembly is allowing sober people who could have smoked pot days earlier to be found guilty of being over the legal limit of THC. So it's all under this A7 statute. And so, the question becomes, what should we do? And the answer I was presented with is change the statute, exclude urine as an appropriate bodily fluid to test in DUI cannabis cases. We should also clarify that Delta 9 THC means parent, also known as free Delta 9 THC, those two terms we started off the episode with. And I've been told that we should prevent labs from turning metabolites back into Delta 9 THC in order to charge defendants with DUI. We should just not allow any sort of chemical processes on people's biological excretions at all, because that is manipulating, I would say, the substance. Anyways, I have been told that House Bill 4890 would specifically exclude urine testing in cannabis cases, which would prevent THC glucuronide from being used to justify the A7 charges. House Bill 4890 does add breath as a possible source of testing. I've been told by experts that using breath will not work as a reliable indicator of impairment. I don't even know if there's a device like that yet. And again, if there is one, who knows if it's reliable? And I've heard in different states that they're trying to like beta test these. And if you ever get off, if you ever are asked to do that, oftentimes it is not mandatory, I must just say, or at least I've heard. Again, I'm not a legal professional, so I can't give that legal advice. House Bill 4890, from what I understand, would define Delta 9 THC, as I said earlier, to include parent or free Delta 9 THC. From what I've been told, saying Delta 9 THC includes parent Delta 9 THC or free THC does not necessarily eliminate misunderstandings, because most people in the scientific community already know that Delta 9 THC only includes parent Delta 9 THC. Experts tell me that a better definition would say that Delta 9 THC means parent Delta 9 THC or free Delta 9 THC. The person I spoke with told me that I'm just looking at this presentation to see if I missed anything. In spite of its limitations, by excluding urine as an appropriate source of testing in DUI cannabis cases, HB 4890 would solve the current source of confusion we are facing. This person that gave me the presentation said they, support HB 4890 over our current law, but ultimately they prefer Senate Bill 3409. Let's talk about Senate Bill 3409. The subject matter expert that I spoke with told me that they thought the Senate bill was a little bit of a better bill, even though it seems to remain silent on whether urine would be allowed. However, Senate Bill 3409 specifically prevents analysts from changing THC metabolites back into parent Delta 9 THC just to charge defendants with being over the limit. My subject matter expert told me that they prefer the Senate bill over the House bill, as I said, because they feel the definition is more clear, but they stressed to me that both bills would prevent THC glucuronide in urine from being used. So while the Senate bill does not specify whether or not urine is used, it does very clearly say that Delta 9 THC means free THC, meaning unchanged, parent Delta 9 THC. I was told the key word here is unchanged, which would prevent labs from manipulating evidence. So in the case of Dwan Thompson that I mentioned earlier, Dwan was found guilty of DUI cannabis, but was not found guilty of driving while impaired. I just want to say that one more time. Dwan was found guilty of DUI cannabis, but was not found guilty of driving while impaired. It's a mind melter. If you're at all like me and you're having trouble understanding how this is possible, I want to remind you that a per se limit is the concept that allows the state to assume you're guilty of driving under the influence, even if the state is unable to prove impairment. So that, if you're wondering, is how Dwan Thompson was found guilty of DUI cannabis based solely on non-psychoactive metabolites in his urine. In other words, he was not found guilty of driving while impaired, but he was found guilty of driving over the limit based on the metabolites that were in his urine. Been told that there are 7 different ways to charge somebody with DUI. I'm not sure if there is a slide on this. Doesn't look like there is. A7 is the per se limit that we mentioned earlier. So this A7 clause, I can try to display it here in a bit. It was like one of the first slides. And I've been told that, like I said, I think I mentioned this earlier, actual THC, even in your blood, does not directly correspond to impairment. The one saving grace, though, with blood testing over urine, whether you're testing for actual THC, is at the very least, they've recently consumed cannabis. This still does not prove impairment, but at least you can see if somebody has recently consumed cannabis within the past few hours. By contrast, based on your analysis, a user can be found to be over the limit by days or even months after they consumed cannabis. Dr. Marilyn Hustis, who I've been told is against cannabis legalization, served as an expert testifying that the interpretation of the statute is wrong and has no connection to impairment. So if you're wondering who Dr. Marilyn Hustis is. I will display her right now on my screen. You can see this huge picture of Dr. Marilyn Hustis. I don't know why the picture is so big, but if you can't see it, now you can. You can notice that this is on Smart Approaches to Marijuana's website, which I always like to say, Smart Approaches to Marijuana is not exactly what it sounds like. I've had Smart Approaches to Marijuana on my show several times. If you'd like to see the most recent episode, it's episode 74. I'll try to remember to put it in the podcast description. I'm displaying it now. I've had them on our show quite a few times. They do not believe cannabis should be legal. So again, this is somebody who doesn't even believe cannabis should be legal. They served as an expert testifying that the interpretation of the statute is wrong and that it has no connection to impairment. I got my hands on that testimony. Let's take a look at it. So in this episode, I will be referencing a transcript. I've been told that, I'm not able to display this transcript, but I will share the case numbers and dates, and you can buy the transcript from the DuPage County Court Reporter. So like I said, you can buy the transcript from the DuPage County Court Reporter. If you'd like to do that, you're going to need to present the case number and date. The case number is 21D as in dog, T as in trumpet, 2300. And the date on the case is April 17th, 2023. So if you'd like to read this testimony for yourself, that's how you do it. I apologize for not being able to display it. I'm just trying to share this in accordance with, I guess, the rules. As a result, I have redacted all visuals where I display the transcript. I wanted to give you a heads up because you might notice that most of the screen is black. A court report of proceeding, and it was signed by Marcia Messina, official court reporter from DuPage County. And I'm not exactly sure from where this is from. Again, I'm not a legal professional, but this has the testimony and examination, cross-examination of Marilyn Hustis, who I just mentioned earlier. And from what I understand, they brought Dr. Hustis in they were seeking to block a UIC analyst's testimony. And the specific UIC analyst, I believe, is Jennifer Bash. More on Jennifer Bash here in a minute. I'll try to see what I've heard about Jennifer Bash, but so I ended up forgetting to return to the subject of Jennifer Bash specifically and what I've heard about them. I will just say that Jennifer Bash is a name that I actually happened to be familiar with when I read this transcript. I was like, wait a minute, is that the name? Oh my gosh, that's the name. So I don't know, how many, pies Jennifer Bash is cooking, but this is the second pie I've come across, for lack of better words. The first time I had heard of Jennifer Bash is in episode 81 of the Cole Memo. I'm displaying that right now. There was a press conference for hemp, and it seemed like they were referencing a study, although it was unclear. And when we found the study that it seemed like they were referencing, it is from none other than Jennifer Bash at the University of Illinois in Chicago at the Analytical Forensic Testing Laboratory. Now, if you do a Google search for Jennifer Bash's name, she actually is listed on CrescoYeltra.com. I'll explain what Cresco Yeltra is in a moment. She is listed on the advisory board as the laboratory science advisor. And as you can see, it does seem to be the same Jennifer Bash. Jennifer, they have listed, is currently a senior analytical forensic toxicology specialist with the Analytical Forensic Testing Laboratory at the University of Illinois, Chicago of Pharmacy. So what the hell is Cresco Yeltra, you might be asking? That's what I was asking. I've never heard of Cresco Yeltra. I've heard of Cresco before. Well, there's this old article from MJ Biz Daily, and I don't know if this is exactly accurate, but this is what I could find. It's a headline from 2018. It looks like it was updated in 2023. The headline is Front End Work, Local Partners and Previous Experience Allowed Cresco to Launch Before Pennsylvania Competitors. And here it says Illinois-based Cresco, operating in Pennsylvania as Cresco Yeltra, started as the only licensed medical marijuana business with an operational grow. Rival dispensaries, once they opened, were forced to stock Cresco supplies. To get up and running in Pennsylvania, Cresco relied on the experience gained establishing medical marijuana operations in Illinois. So Charlie Bachtel is quoted in this, and it does seem that Cresco Yeltra and Cresco are one and the same. And that's my little bit of a tangent on Jennifer Bash. If you'd like to see the episode that I referenced earlier, I believe that is episode 81 of the Cole Memo, which references the study that Jennifer Bash made. But this is almost completely unrelated, other than the fact that it does seem to be the same Jennifer Bash. Let's get back to the show and talk about this messed up issue. On page 19 and 20, I've got noted that, so how did we end up here? I'm going to read some of this transcript. Well, Jennifer Bash did testing. I believe this is from the lawyer. Let me see who's saying this. Yeah, so the lawyer who I believe represented Dwan Thompson, Kevin McMahon. I'm skipping down a bit. So how do we end up here? Well, Jennifer Bash did testing, exactly the same type of testing on another individual going on 6 years ago. That individual is named Dwan Thompson. So when she did the test, she did the same things, came back with similar results, and she testified under oath that conjugated THC, also known as THC glucuronide, I'm going to say, is not a different molecule than Delta 9 THC. And folks, I want to put it in a bottle here. This is the main debate. This is like past this. It seems like this is the main debate about this, is whether or not Delta 9 THC is the same thing as conjugated THC, otherwise known as THC glucuronide. And I mean, clearly it is, right? We just watched that video. Clearly it is a different molecule. And I'm not even, credentialed at all as a scientist or anything else. So I'll continue reading. She testified under oath that in order to change one molecule into another, you have to change a carbon bond. She testified that the physical properties were not changed, that it's similar to just two people holding hands. And if you break those, if they stop holding hands, they're the same people. It doesn't make a difference. So she said all these things under oath. The trial court found Mr. Thompson guilty, largely based on that testimony. The appellate court affirmed that finding of guilt, largely based on that testimony. There was no Fry hearing conducted. So what we're trying to do here is prevent Miss Bash from repeating those claims that conjugated THC is not a different molecule and that conjugated THC does not have different physical properties than Delta 9 THC. Okay. So that's the goal. I want to repeat that. That's the goal, apparently, of having Dr. Hustis testify, is to prevent this UIC analyst, Jennifer Bash, from repeating claims that conjugated THC is not a different molecule and that conjugated THC does not have different physical properties from Delta 9 THC. So this is a good old-fashioned nerdy debate, except for the fact that the outcome of this is really serious. And that's why they're trying to prevent her from testifying, because if I could put it plainly, from my perspective, it's that they believe Jennifer Bash's perspective on this is flawed, or in other words, incorrect, and that it is causing people to be locked up when they're not, in fact, intoxicated. And from what I understand, Jennifer Bash disagrees with this idea based on her testimony. She's not in this, what we're about to read. I believe if you read through this, you'll find that she was not able to make it that day because she had COVID. So let's scroll down to page 28, which is when Dr. Marilyn Hustis gets introduced. So this is on, I believe, page 28. Yep, where Marilyn Hustis gets called as a witness on behalf of the defendants, having been first duly sworn. They testified as follows. So they spelled their name. Are you employed? They say, yes, I wear a lot of hats. I'm president of Hustis and Smith Toxicology. I'm a senior policy advisor to Penny Associates. I'm the director of cannabinoids and science, a master's program, co-director of at Tom Jefferson University, and I have 3 other adjunct professor positions. We're going to get into your resume a little bit. I'd like to seek. Okay, they present her CV, which from what I understand is like their resume. They're going to start talking about their background. You know, it's over 100 pages, their CV. It's a very big, you know, CV because they have such an extensive background. They have a bachelor's degree in biochemistry from Mount Holyoke College, one of the 7 Sisters schools, a master's in clinical chemistry from the University of New Mexico, a doctorate in toxicology from the University of Maryland, an honorary doctoral degree in medicine and surgery from the Faculty of Medicine, Helsinki, Finland. They've been in the lab. They're primarily in toxicology. They are the past president and the first woman president of the International Association of Forensic Toxicologists, the past president of the Society of Forensic Toxicologists. You know, you get it. This is the interesting one that I wanted to mention. The defense lawyer, I believe, Mr. McMahon, asks, are there any others that you care to mention, any other roles that you're currently serving in? Are you by chance involved in an organization called Smart Approaches to Marijuana? Yes, Dr. Hustis says. So I'm on the Scientific Advisory Committee of Smart Approaches to Marijuana, or SAM, and we are advising on the science to promote the medical use of cannabinoids but prevent the legalization of cannabis. By the way, this is such an interesting description of SAM. You know, a lot of people say things about SAM. I've never seen them. I feel like I've never seen them described this way. They are advising on the science to promote the medical use of cannabinoids, but prevent the legalization of cannabis. They always just seem like they're opposed to it altogether. So, and actually, this is what he asks. So you're actually opposed to legalizing cannabis, is that correct? Yes, I think that there's much less disease and death caused by cannabis than, let's say, alcohol or nicotine. But the reason I feel strongly is because of drug impaired driving and because of the effects of cannabis on the developing brain, because it has tremendous effects in utero if the mother is pregnant and using, you know, obviously when adolescents start using, breastfeeding, those kind of, I've done a lot of research on in utero drug exposure, and I'm very concerned about the developing brain. So they go through some of their accomplishments. You can see they've gotten a lot of awards at the International Cannabinoid Research Society. I thought it was also notable to mention that they have 555 papers that are peer-reviewed, I believe, and drugs and driving, analysis of drugs and metabolites and biological specimens, therapeutic drugs, monitoring of drugs, drug abuse and addiction, in utero, drug exposure, novel psychoactive substances, general toxicology, all of that stuff. She's these are the topics she's published in. So about 40% of her publications are related to cannabis use. So she works 23 years as a senior tenured investigator at the National Institute on Drug Abuse, which I thought was very interesting. She talks about being given permission, I believe, on page 37. Yeah, so you can see the federal government signed off on you giving these Schedule 1 drugs to individuals. Yes, it's with great oversight by the FDA, the DEA, ethical committees, you know, a lot of oversight, and only to drug users. We never give drugs to naive individuals. And also you had to have very good risk benefit ratio so that we never wanted to do harm. But these are volunteers. I'd like to volunteer for that. And then we could study and learn a great deal about the effects of these drugs. So it helps us in developing therapeutic medications, in understanding addiction, and creating both behavioral therapies and pharmacotherapies to create addictions. She was the principal investigator on these. Did any of those studies relate to cannabis use specifically? Yes, probably most. I did studies on heroin and methamphetamine and coke, ecstasy, lots of other drugs. But my main area and subject of my dissertation, my doctoral dissertation, was on cannabinoids. On page 38, the defense lawyer asks, I'm going to ask you, have you ever done any research yourself at the National Institute of Health on a molecule called THC glucuronide? They say yes. Dr. Hustis says yes. The defense lawyer asks, is that also known by another name called conjugated THC? Dr. Hustis says yes. And can you describe for the judge, just very briefly, any of your studies related to THC glucuronide? So she lists a few, and she asks, the defense lawyer asks, have you ever done any studies related to the length of time that THC glucuronide stays in the body? Yes. Can you just briefly describe that to the judge? So we've measured it and found no THC in the urine of occasional users. We have done it in chronic, frequently daily cannabis users and have found no free THC. You remember that term? That's delta-9 THC. No free THC in the urine of the chronic frequent cannabis users. And we were published in multiple papers. What about THC glucuronide? Did you find, and she says, so THC glucuronide is a minor metabolite. The primary metabolites are these. I'm not going to try to pronounce them. In chronic frequent cannabis users, we were able to measure THC glucuronide in their urine up to 24 days after last use in individuals that resided on our closed research unit with no access to drugs and no visitors. So it can be present in the urine of chronic frequent users for a long period of time. So let's continue. On page 42, she talks about the role of the cannabinoid system, how it's there for critical survival functions. It's involved with memory. It's involved with temperature, body control, all that stuff. She mentions THC is a very lipophilic compound. It likes fats. It's not water soluble, right? It's lipophilic. That's why cannabis can stay in your system so long. It oftentimes bonds to your fats in your body. I should say, from what I've heard. Here's where we get to some interesting questions from Mr. McMahon, the defense lawyer. Does the term delta-9 THC refer to more than one molecule? Answer from Dr. Hustis, no. So is it your opinion that it refers only to one molecule? Correct. So I'm going to turn our attention to that other molecule we were just talking about, THC glucuronide. And they describe to the judge that THC glucuronide is a metabolite of THC the body produces in order to improve its ability to excrete it. It has a different molecular weight. It has a different polarity. It has no activity has been shown for the THC glucuronide molecule at all. And they cut her off there. And they ask her, when you say it has no activity, does that mean, or no known activity, does that mean it is not known to get people high? Correct. And they said, sorry, I didn't mean to cut you off. You previously mentioned that delta-9 THC is not very water soluble. So what is your opinion on THC glucuronide? It's more water soluble. So they go through gas chromatography and talk about how the molecular weight is different. And how they work in mass spectrometry. And there really just seems like underscoring the point that these are different molecules. So I wanted to scroll down a little bit here. So to my point that I mentioned earlier, the defense asks, so you said the molecular weight of THC is that different or the same as THC glucuronide? Very different. The polarity, very different. And the retention time, also different. Does this in part form your opinion that they are two different molecules? Absolutely. And is this a fair and accurate depiction of the study that you and your colleagues published? Yes, and we have others after it, multiple others after it. So I thought it was interesting on page 53 that it mentions, that multiple drugs are lipophilic. In other words, they're fat liking. The body does a similar thing to metabolize those drugs by also adding glucuronide to it to make it more polar and more easily excretable. And those would include something like morphine to morphine glucuronide, benzodiazepines to their glucuronides. And the questions asked, are there any glucuronide metabolites that are the same molecule as their parent compound? No. Are there any glucuronide metabolites that the toxicology community treats as being the same molecule as the parent compound? The answer by Dr. Hustis, no. After some objections, the court ultimately allowed Mr. McMahon to continue with his questioning and asking Dr. Hustis on page 56, Doctor, just starting very broadly, what was Miss Bash describing? So this is the answer from Dr. Hustis. So Miss Bash used liquid chromatography mass spectrometry, LC-MS/MS, for analyzing urine specimens, and she analyzed them not hydrolyzed and hydrolyzed. I meant to say analyzing them not hydrolyzed and hydrolyzed. So she was looking for only THC, and it's quite interesting because you don't need to hydrolyze. The LCMS could measure the THC alone and the THC glucuronide alone, and I'm going to stop you right there. You say it's unusual. Do you mean it's unusual to do hydrolysis, or do you mean it's unusual to do hydrolysis alongside LCMS? And she said, well, we had to hydrolyze with gas chromatography, mass spectrometry. I am not saying these well. I'm sorry, folks, because THC glucuronide is a compound that is not volatile and won't get into the gas phase, so we could measure it in GCMS. You can measure the THC and the THC glucuronide without hydrolysis. So hydrolysis takes time, it takes money, and once you do it, you can't separate what produced the THC. Now, when Jennifer Bash did the hydrolysis, she did it without hydrolysis and showed no free THC in her reports. I saw one report where THC, all the others had none. Somebody objected. The court says, what's the objection? I don't know what report she's speaking of. I can clarify, Judge. Sure. Doctor, have you just reviewed literally the face lab reports from UIC that were published and given to the defense regarding the 10 individuals, although now 9 individuals who are the subject of this motion? Yes. Did you review any of the lab notes in relation to those? No, and no chromatograms. So it is fair to say you've reviewed transcripts as well as just the face sheet of the yes. Okay. So she analyzed them without hydrolysis. Let's pause this for just a moment. On page 60 is where Dr. Hustis describes, I think, why this is problematic. So she's saying, she references the Illinois statute, and she's saying that there is no THC in urine. No free delta-9 THC can be found in urine. We've run multiple studies showing that there's no free THC in urine. Also, the group from Colombia found no free THC. Also, a group in Germany found no free THC. So by doing hydrolysis, she turns THC glucuronide, which is an active metabolite that is present in the urine for a very long can be present in the urine for a very long period of time, into free THC, and then uses that as a means to say that the individual had greater than or equal to 10 nanograms per milliliter. And the defense asks, so is it your testimony that she's actually turning THC glucuronide into delta-9 THC in the lab? Dr. Hustis says, correct. So this is another interesting part of the transcript, doctor, in your opinion, how the claim that conjugated THC or THC glucuronide is not a different molecule than delta 9 THC, is that an accurate claim? Objection, overruled. Judge, may I stay? So you have some things here. Not the defense, but the state says their objection is relevance. There's nowhere anywhere in this transcript that Jennifer Bash says that. In other words, the claim that conjugated THC is not a different, or is a different molecule than delta 9 THC. And the defense responds that they would submit that she does in so many words say that. And so Mr. McMahon asks Dr. Hustis once again, is it generally accepted in the scientific community that free delta 9 THC, as in delta 9 THC, is a different molecule than THC glucuronide? The answer is yes. And if I can expand that on that, I believe that she does say in that deposition that they are the same. So I believe she actually reads from the deposition what she's referring to in a moment. But first, they ask, how many years have they been working in the field of toxicology? Hustis answers, more than 50 years. How many toxicologists have you worked with and interacted with? She says hundreds. How many have you worked with and interacted with on THC-related issues? She says hundreds. Have you ever recalled hearing a toxicologist say that delta 9 THC is not a different molecule than THC glucuronide? No. And doctor, have you ever heard of a toxicologist say or imply that THC and THC glucuronide do not have different physical or chemical properties? No. Have you ever recalled hearing a toxicologist claim that any mind-altering substance is not a different molecule than its glucuronide metabolite? No. And they stopped with no more questions. This is where cross-examination comes into play. This is, I think, a very interesting moment in cross-examination on page 69. The state asks the witness, which is Dr. Hustis, the state asks, in that 33 pages or so, can you point me to the page and line where Jennifer Bash is either asked a question or gives an answer and says that delta 9 THC glucuronide is the same molecule as delta 9 THC? And Hustis says, okay, give me a minute to find it. Okay, please take as much time as you need. Okay, so I'm starting on page 68, line 21, and line 16 says, from the tests you performed, were you able to form an opinion to the presence of any drugs in the defendant's urine? Yes, I was. What is your opinion? I found THC at concentration of 27.3 plus or minus 3.3 nanograms per milliliter. You indicated in your results also that you did not detect any free tetrahydrocannabinol. That's correct. Can you explain what that means? When the body is metabolizing certain compounds, it will add a complex molecule called glucuronide that is simply to be able to allow the body to pass that compound into urine. What we do when we quantify and test for the presence of THC is look for the levels. For the levels is we have some samples that go through a hydrolysis process that removes that glucuronide, and then we have a sample that does not go through that process, and we look for if there's anything that doesn't have the glucuronide attached to it. And then you're saying glucuronide, and she spells it. What's the purpose of removing that? It allows us to then pull the drug compound out of the urine and into an organic solvent. Otherwise, the drug compound will simply stay within what we call the aqueous phase, or the water portion. If you can just clarify, when you remove the glucuronide, is that free THC? The free THC compound would be the compound where the body never attached that glucuronide. Once you get the hydrolysis step, then it's all the same molecule, whether it was glucuronidated from the body or not. It's all the exact same compound, all delta 9 tetrahydrocannabinol. And there are other portions also in the document that I can recall. I would look through it if you want me to. And then the state says, okay, but in that testimony, she says that THC glucuronide, or the glucuronidated THC, when you move the glucuronide, what does it become? THC. Okay. She says it's all the same molecule, whether it was glucuronidated from the body or not. It's all the exact same molecule, all delta 9 THC. After the glucuronide is removed, Dr. Hustis it looks like cuts her off. She says it's all the same molecule. And then the state says, well, that's your interpretation of you breaking down what she said. And Dr. Eustace says, I think that is very clear what it says. And then the state says, well, she says after she takes the glucuronide off, it's the same molecule. Is that Dr. Eustace cuts the state off and says, it's all the same molecule, whether it was glucuronidated or not. I can't say that word. I'm so sorry, but she's quoting Jennifer Bash. The state, after she talks about removing, Dr. Hughes cuts her off. No, she says it's all the same molecule, whether it was glucuronidated by the body or not. And she specifically references going through the hydrolysis step, the state asks. She answers yes. So very interesting back and forth here. So this is part of the testimony is what I was referring to earlier. Dr. Eustace says, when we started studying chronic frequent cannabis users, because carboxy-THC, which is the primary analyte in the urine, is there for weeks to months. I've measured it for months in individuals. It tells you nothing about the recency of use. So we were looking for different markers that might possibly be able to identify recency of use. Once again, that's on page 74 of this Fry motion hearing featuring Dr. Eustace. Page 91 has an interesting interaction between the state and Dr. Eustace. The state says, well, in her testimony, she references that her lab is certified, correct? Dr. Eustace says certified, but it doesn't say the procedure is certified. The state responds ANAB certified, correct? Dr. Eustace responds yes. It doesn't say the procedure is certified. So I thought that was just an interesting point there. Earlier in the episode, when I said that, UIC seems to be one of the only labs, I've been told that from several, from, my source, but also, I'm gathering that from this testimony here, where Dr. Eustace says, I do want to say that this is the only time I've ever seen urine tested like this for a DUID case around the world. I've never seen people take the THC glucuronide and turn it into THC and use that as the basis for meeting your statute's requirements. Thought that was a very interesting moment in this testimony. There's more to this, and I recommend that you go through and read the rest of the testimony. Like, they end up having somebody from organic chemistry, and they ask, is delta-9 glucuronide and delta-9 THC treated as the same compound and molecule in organic chemistry? I believe the answer is no. And I might actually have one more that I'd like to show you from this testimony from this organic chemist. Let's pull it up on the transcript. So this part is, like I said, a different person. This is no longer Dr. Eustace. I can try to find the name of the individual in a moment. The individual that I'm about to read testimony from is Dr. Christopher Check. But the point I wanted to make is this is a different individual, and the question from, I believe, the defense asks about testimony that Jennifer Bash gave. So they say that she says the complexations are actually considered different than if you are changing an entire molecule. What is your opinion based on that statement she testified to? The answer was no. Minor changes change the molecule completely. And you've been studying and working in the field of organic chemistry for approximately 20 years? Yes. And at some point you learned about molecules and probably the beginning of your education? Yes. And what is the definition of a molecule that you've learned? So a molecule is a group of bonded atoms that can be identified as a distinct entity. So the defense asks, okay. And then in the second portion of the testimony where Bash says to actually change one of the molecules into another, you need to actually form some sort of carbon bond or remove some sort of a carbon bond. What is your opinion regarding the truth of that statement? Answer. Well, you are forming a carbon bond in the case of this reaction, so that's confusing. And then that's not the definition of how you change a molecule or what a chemical reaction is. Now, based on your education and training in organic chemistry, how can you, if you change any bond, and so any bond, it doesn't have to be a carbon bond, it can, correct, be any bond. Okay, showing you what's been marked. These are two structures, so they're showing the structures that I showed earlier. And they're basically asking, are they different structures? And these expert witnesses seem to be saying yes. So I thought this was a very interesting back and forth between the state and the one of the expert witnesses. The question from the state: in your studies, have you come to learn that in order for Delta 9 to be eliminated by the body, it has to be conjugated to get into the urinary tract and eliminated? Yes, that's part of the metabolic process. The subject matter expert answers. The state asks, okay, so part of the metabolic process is the attachment of the glucuronide. The expert says, yeah, it's a functional handle. The state asks, I'm sorry, what did you say? The expert answers, it's a functional handle. The state asks, a functional handle, is that a term that you use in organic chemistry? Yes. What's a functional handle? The expert says, so you could describe it as something like if you want to take something out of an oven, you put a glove on it so that you can then grab it and take it out of the oven. So that's like a functional handle. You're changing like a pot by putting a glove on or a mitt around it so that you can transfer it. The state asks, so you're not really changing the chemical structure of the pot by using the expert says, you are, unless, right. That's just an analogy. So you would change, and the state says, let me slow you down there for a minute. So you would agree that an analogy is just a way to kind of explain something in lay terms for somebody who's got it, who's not an organic chemist, correct? The expert says yes. Oh, and the state says, okay, I have no further questions. So I think their point in that is to say that maybe Jennifer Bash was not saying what she apparently said, but instead she was making some sort of analogy. And you can find that in other parts of this document. I'm going to do a quick control F. I think you can find the word revealed. They try to say, you know, well, you're not creating a document, it reveals itself. So when you're saying it's an aggregate of the free and the conjugate, it's really just the conjugate exposed or revealed, right? So there's questions about that. And it sounds like the state is trying to say, it sounds like, again, just from a layperson's point of view, it sounds like the state is trying to say that the testimony given is factual, even though, as we've gone through the science, it doesn't seem to be factual. And I think what they're then saying is, okay, yeah, you're right. That is not factual, but what we meant is this, and that's what, and I think they're even taking it a step further. Not only did we mean that, but that is the definition, this sum of these two samples. You know, you've got your conjugated THC, but then you have the one that you hydrolyze and you get the free THC. And they're saying that what you had in your system is what they're finding, and they stand by those results. And I just have to say that if everything I've been told is true and I'm understanding it correctly, this is fucking crazy. I've always said that I doubt I could pass one of these tests, but now I feel very confident that I would not be able to pass one of these tests. And it's one of the reasons I wanted to record today's episode, because it's almost like a red flag that I wanted to put out for all of you. Again, I started this episode by asking if you've used cannabis in the last month or so. You might need to think a little bit about, you know, operating a motor vehicle, at least within the state of Illinois. So, folks, what do you think about this? Let me know. You can go to thecolememo.com/contact to send your feedback. And I hope that you found value in this episode of the Cole Memo. I will see you on the next one. Be sure to check out the show notes for, you know, links to the documents and so much more. Take care, everybody.